Hello, everyone. Welcome to another session with View Medi. I'm Jeff Segal, founder and CEO of Medical Justice. We're focused on keeping doctors from being sued for frivolous reasons. We also manage a range of medical legal conflicts, including problems with the medical board, National Practitioner Data Bank, hospitals, employees. If you can name it, we have seen it. I'm also a neurosurgeon by way of background, and I went over to the dark side and I'm a lawyer, but not really the dark side because I defend doctors. All right, today, what are we going to chat about? We're going to talk about documentation and problems. I know everybody's thinking documentation, what a big snooze fest. That is so boring. I would rather swallow a porcupine. Well, this isn't going to be that long, and I think there will be several actionable pearls that may keep you out of hot water here. All right. So poor documentation is common. I honestly, when I review charts, I do not believe I've ever seen a perfect chart. There are always problems in every chart. The question is, are they insurmountable problems? Or are they modest problems that can be explained away? And the reason is simple. You're taking care of patients. Patients are the primary priority. And in the moment, a good enough note seems good enough. And we've certainly moved over to templates, and the templates save time, but sometimes they don't accurately describe precisely what's going on. And I think doctors often believe that they'll get to it, that if they do the documentation 3, 4 days, 1 week later, they can fill in the gaps, but something else always replaces that time. And so there's always a bit of a vacuum there. And for most of us, and including me, the record always seems secondary to the care. I can't be in two places at one time. I could certainly be the perfect documenter, but then I'd be kind of a mediocre or rotten clinician. I would certainly prefer to be the better clinician and hope that the documentation supported what I actually did. All right. So the chart is what is used in medical legal conundrums. They are treated almost as witnesses, and the credibility flows from what is documented, not what you later interpreted or later what you thought. It's contemporaneous, and the chart does the talking for you. And this is, in fact, we had um, a physician yesterday. She's being deposed for a auto accident case. She's not in the crosshairs, but she's a fact witness, and the auto accident occurred in 2020. It's now almost 6 years later as I'm recording this. And she says, "Well, what am I supposed to do?" I said, "Simple. Just read the record. You're a fact record. You're not looking for any interpretation. You're just looking to reconstruct what happened. You entered information or data into the chart. Just read back the chart, and to the extent you can make some interpretations from what you wrote, then feel free to do so, but don't speculate. The chart is the chart." All right, so here's an unhelpful post-op documentation. It's brief. The note says, quote unquote, "looks fine." There is no comment on the color, whether there's any drainage, no size. There's no discussion or no documentation of discussion of what happens when things go wrong, meaning no red flag counseling. What is the patient supposed to do if they have 99 fever versus 104 fever? They should have been given instructions, and that should be documented, and you can just point to what you gave them, but you definitely need to alert them as to what is a red flag. You shouldn't just leave caution to the wind and have them consult with ChatGPT or Google on the back end and hope for the best. And if there is a later complication, the fact that the record was sparse will be a problem. So here's litigation. And look, I didn't come up with this phrase, so please do not kill the messenger. This is a common phrase that's been present for probably a century. If it isn't documented, it didn't happen. Let me repeat, if it isn't documented, it didn't happen. Now, I didn't make that up, and I don't think it's true. I think that there are things that actually did happen that didn't make into the documentation. I think the larger point is that you will not get credit for it. So even if it did happen, if you want to get credit for it, months to years later, when you're in front of judge and jury, it needs to be in the chart. Why is that? Because judges and juries believe that the contemporaneous record is important and more reliable over memory, months to years down the road. And if you have very little in the chart and the documentation doesn't say very much, there will be additional pressure from your carrier and from your attorney to make this go away, which means writing a check, which means getting reported to the data bank, which means having to explain this to the medical licensing board, and more, and on and on. All right. Electronic medical records. Some of the issues and problems is that the the templates get cloned, the data gets cloned from the past. So if there's a change, that change isn't necessarily reflected in the updated, more contemporaneous record. And if you are just cloning, it gives the impression of laziness. Now, there's a reason to clone if indeed you've had an opportunity to review it, and that makes all the sense in the world. But if something has changed, you need to document what the change has been. And if there was no discussion of something, you probably shouldn't put it in the record. I still remember a case of doctors taking care of a patient for a gallbladder and had a giant template which said something to the effect it included a family history, which I'm sure was never done. The family history said no history of liver disease. Well, it turned out the patient's brother had a liver transplant for alpha-1 antitrypsin deficiency. So it's hard to conclude that someone with a liver transplant had no family history of liver disease. And this made this even more challenging when the patient returned, when the gallbladder patient returned, about a year later um, with his own liver problem. He ultimately needed to have a liver transplant. Why? Because he also had alpha-1 antitrypsin deficiency, ran in their family. But there was a gap in time, and this became Exhibit A. It says you didn't get, you said there was no family history of liver disease, but in point of fact, there was a family history and there was a missed opportunity and so on and so forth. I don't know that it would have changed the clinical outcome, but at the very least, it's embarrassing. And, arguably, it certainly created settlement pressure to get a check written to the patient. All right. It's helpful if people can actually, if the jury, the opposing side can see what you were thinking, um, if they can identify your judgment. If you order a test and the patient just doesn't do it, you should comment on it. You could say, I ordered it, but the patient decided on their own not to get it for whatever reason, but you still counseled them as to the reason for getting the test and the risk associated with not getting it. That certainly looks better than CT deferred. CT deferred means that you decided to defer the CT. It doesn't mean the patient made an autonomous decision to avoid the test or decline the test, actually. So who's the agent here? Is it you saying, you don't really need to get the CAT scan? Or is the patient saying, look, I hear what you're saying, doctor. I understand the risk. I'm willing to assume those risks. Those are two different documentation pathways. And, we respect our patients' right to decide the type of care they want and from whom. And if they make a decision not to get an MR scan, or if they want to delay it, that's their call. You're not a policeman. You can't force them to do what they don't want to do. But you should document that you explain the risk and benefits and options, and this is their decision. The patient in the medical legal world will assume responsibility for the decision if they properly understood the risk of foregoing a particular test. So documentation defines where your judgment actually does become defensible. All right, this happens pretty frequently. A critical result comes through. You actually looked at it, but you didn't write it down. Or sometimes the result comes in, but you don't see it because your office doesn't appreciate the importance of it. I mean, I would argue that if there's a life-threatening result from a lab or imaging study, it's it's ideal for the lab and or the radiologist to pick up the phone and call, not to leave it to the electronic system to assume that it was seen and acted upon. That's my perfect world, but I can tell you that if there's a critical result that comes through, you really do need a system in place to manage this. If there are red flags, somebody in your office, perhaps even two people, should make sure that there's an action associated with it, and that action involves, follow-up patient care, patient notification, and documentation in the medical record. Um, if it doesn't go into the medical record, it will be assumed, perhaps correctly, that nobody took any action on this critical result and it fell through the cracks. Because it fell through the cracks, the patient was impacted, perhaps injured, perhaps died. So red flags, if you ordered it and there's a red flag, you're going to be accountable for it typically. I mean, there are situations where it's defensible. You could say, yes, this is a red flag, but it didn't cause the damages, didn't cause the damages. And we did a webinar on the different um, ingredients for a medical malpractice lawsuit. It includes a breach of a standard of care causing damages. So the plaintiff has to run the board. They need to say you breached the standard of care. That breach caused damages. So if you're not reviewing a red flag record and acting on it, arguably that is a breach in the standard of care. I mean, if you're going to order something and something is way off, you should at least acknowledge it somehow, even if you're not going to act on it, but you should at least put some judgment into it. But it doesn't mean that if you're sued, you have no defense. It could be your argument would be there was no reason to act on it because there was nothing to do and it didn't cause the patient's damage. So there are still defenses, but it's just easier if you acknowledge red flag results when they come in and take some action on it, certainly in the documentation paper trail. All right. What happens if you are in the shower and you remember, I should have put something in the chart? Okay. Can you do that? Is it too late? No, it's not too late. I would argue you should, put everything that happened in the chart, but it needs to be labeled as an amendment, meaning that if you took care of the patient on January 1st and this epiphany in the shower happened on January 10th, you're going to enter into the chart labeled January 10th. It could be about the care, from January 1st, but you're going to label it as an amendment from on January 10th and date and sign when it was entered in the chart. It doesn't mean that you're trying to change the chart. You are amending the chart. Let me repeat. You are not changing the chart. You are amending the chart. The original content is as it is. You're not deleting something. You're not making a silent edit. Um, Will a plaintiff attorney try to argue that this amendment was self-serving? Yeah, maybe. They may try to do that, but I'd rather defend that, 10 days later than to try and defend it in a courtroom 2 years later or defend it 6 months later. So, if it's something that took place and it's accurate, just put it into the chart on the date that you actually put it into the chart and make sure the date reflects when you stuffed it into the chart, and do not delete any prior records. The original record should stay. And if you made a mistake in the original chart, leave the original record as is and correct it as an amendment. The original record stays as is. You don't make any edits. You don't remove the pages. You don't try to cut it out. You update it and you amend it. All right, what about telemedicine? People think that telemedicine has a different standard of care. No, actually, telemedicine has the same standard of care as in-person visits. It is more convenient, and there are many things that telemedicine will do just as well. But there's sometimes when you actually do need to ask the patient to come in, and you should know the difference. So telemedicine is helpful, but it doesn't mean because you're doing telemedicine that you're given a hall pass. It's just not true. And sometimes some of the challenges might be that if you're looking at something and trying to make a determination, the lighting may be off, the scale may be off. You've only got 2 dimensions. You don't have 3 dimensions. Sometimes patient will send pictures of their post-operative wound to the doctor. It is often very helpful, but because it's not the exact same as an in-person evaluation, things can be missed. So I do think that if there's any um, belief that you don't have ideal information, you should always have an escalation and follow a plan to bring the patient into the office or have them go to an urgent care center or emergency department. So the duty is the same. The standard of care is unchanged. Telemedicine, certainly more convenient for the doctor and for the patient, but you are working with probably one hand tied behind your back. All right. So what happens with cases and documentation and how this becomes a challenge? A deeply abridged note may make it harder for your expert to actually come to conclusion. So ultimately, professional liability cases are battles of the experts. Each side will hire experts to determine what was the standard of care and what caused the damages. But if there's little to go on, your expert will not have much in the way to understand your judgment, why you did what you did, and the other side's expert will just conclude, well, there's nothing in there. So he put no thought into it, which often is not fair. Anyway, if the case goes to mediation before trial, the mediator going back and forth between the two rooms between the plaintiff and defendant will bring up the fact that the documentation is weak, it is thin, and this is not helpful to your defense. And then the claim adjuster, who may be sitting in the mediation, will say, look, let's try and get this case settled, while the going is good, because the value of this case may go up as they make their case to court. And then finally, if the case goes to a board of medicine and there's very limited documentation, they may come to the same conclusion. And boards of medicine really are focused on the standard of care. They don't necessarily care as much as to whether a breach in the standard of care caused an injury. They're more focused on just standard of care breaches. In court, for a plaintiff, your patient to prevail in a med mal case, they need to run the board. They need to demonstrate that you breached the standard of care and that breach caused damages, lots of stuff. But with the board of medicine, they're just looking at whether the whether you breach the standard of care. It's possible that there was no injury, there was no causation. They may not prioritize that case, but they are not looking for as much to create havoc in your life. So why are records important? Well, they're created while you're delivering care. It's made at or near the time of the actual event, and people use these types of records every day across the country. So they're considered to be reliable. They're given enhanced credibility under the rules of evidence. Again, I didn't make the rules of evidence, but I can tell you over the decades, the medical record is treated as reasonably sacred, which means you don't want to spoil it. You don't want to pull pages out. You don't want to delete it. There's a proper way to update, a proper way to amend. But the more information you have in there and the more a third party, an independent third party, can evaluate your clinical reasoning, the more likely you will survive an assault on the care that you delivered. All right, so I know people are thinking, well, so what? Now I've got to write 15-page notes. So more data, but less information, more noise, less signal. No, actually not. I think that crisp, pithy notes are very helpful. They do not need to be 30 pages long. But I think you need to define what it is you were doing. Use language. Don't just say healing fine. You can add an extra sentence that describes what you actually saw, and it will save you, particularly if the patient ends up with a complication after the fact. I do like the idea of having in the medical records warnings to patients as to what they should look for when they're at home if there's a problem. What are the clinical findings that should increase their caution and reach for help if indeed they see this? And you want to tell people what would trigger a telephone call, what would trigger a visit to an urgent care center, emergency department. I'm not advocating for 20-page notes, but I am advocating for those two extra sentences that define what you did and what you saw. So here's an example of pretty decent documentation. It has got sufficient details in there. It's got sufficient warnings to the patient. It defines when the patient is next going to be seen. So here, the size of the incision, 4 centimeters, edges approximated, no erythema. It looks like it's healing well. Pain is modest. There's not requiring dramatic narcotics to treat it, just Tylenol. A discussion with the patient of a new fever greater than here 101.5, redness, pus coming out, drainage, worsening pain. I mean, you would think that most of these things are obvious, and certainly if a patient went to Google or ChatGPT, they would get the same advice. But it's better if it's in your chart than telling the patient if you have any issues, go to Google or ChatGPT to try and guess what the next step should be. Then, same day care if any of these findings take place, or send them to an urgent care or emergency department. Otherwise, follow up 1 week. It's a great note. It's a great post-op note. I'm not saying that's the perfect note, but it's certainly a better note than healing well. All right, so the various final thoughts here. If you add an update or amendment, did you do it properly? Or did you just ignore it? I mean, if you really do want to add to the record, do it, but do it properly. Just make sure it's a contemporaneous note, signed and dated on the date that you entered it. Don't rely upon your memory 4 years later to fill in the gaps. Um, Sometimes people ask, does the answer differ for litigation versus a board of medicine inquiry? I don't think it differs at all. I think the record is a record. It's the same record that would go out to a plaintiff's attorney or to an investigator for the board of medicine. Um, and then mostly going forward, you just want to make sure that there's enough information for a third party, an independent third party, to evaluate the type of care you rendered, the judgment that you used in making certain decisions. And if a patient says, I'm not going to participate and they're going to be non-compliant, just stick it in the record. I mean, it doesn't make them a bad person. Sometimes people make decisions for all types of reasons. Could be money, could be they didn't understand the risk of not getting a particular procedure or lab, but document that. Document the patient is making an informed decision, that they know precisely what they're doing. All right, so to wrap up, um, minor documentation differences can mean the difference between medical legal liability and no problem whatsoever. And the type of documentation often determines the settlement value and or the defensibility of a case. And to me, the best insurance is just a clear and concise note that describes what you did, why you did it. If you have to make an updated correction down the road, do it properly. If the patient is non-compliant or reasonably wants to choose a different path, just document that and explain why the patient made that choice after they were fully informed. All right, that is our whirlwind tour. I did promise you this would not be a snoozer. I hope I lived up to that promise. Normally, I tell people that a discussion on documentation is like swallowing a porcupine, something you would rather not do. If you have any questions, Pete, please feel free to reach out to us at info@medicaljustice.com. Again, info@medicaljustice.com. There should be a QR code on the bottom right hand of your screen that takes you to our scheduling page where you are treated to 15 to 20 minutes of a free medical legal consultation. That's 15 to 20 minutes of a free medical legal consultation. Again, that's the QR code at the bottom right-hand portion of your page, www.medicaljustice.com. So in short, we've been at this for over 2 decades, dealing with all types of medical legal conundrums, including conflicts with patient, frivolous lawsuits, challenges with the National Practitioner Data Bank, employee problems, exit agreements, notices of intent to sue, board complaints, and on and on. This list is not exhaustive, but if you do have a medical legal challenge and you'd like to take advantage of the 15 to 20-minute free consultation, just go to medicaljustice.com or go to the QR code. It will take you straight to our scheduling page. And with that, I bid you adieu until the next time. Thanks for listening.